Good morning, welcome. Very good to see you. Thank you for sparing the time to come and talk to us this morning. You probably know we are the youngest select committee in the House, the Political and Constitutional Reform Select Committee, created at the advent of the new coalition government because the Deputy Prime Minister was given specific responsibilities in a particular area. Therefore, there should be a select committee to keep an eye on all things to do with the Deputy Prime Minister and to hold that part of government to account. One of the major areas of responsibility is around what you might loosely term the democratic agenda and political reform. And therefore, the committee has been looking at the concept of the Constitution. Is there such a beast? Should that be written down? What are the processes around moving that forward? Is there a need for reform? And looking at it from a very broad perspective, one of the things we're doing with our time over the next 3 years is to examine whether there should be a written constitution, hopefully outlining at some length the arguments against and the arguments for, and possibly what a process might look like if people wanted to move forward on that. So we are taking evidence almost on an occasional basis around our other more immediate pressing matters that we have to deal with as a committee, and that's why you are here today. Thank you for coming today, and can I apologise for the sort of difficulty we had last time. I think there was industrial action which meant the proceedings had to be cancelled. I hope that didn't cause too much inconvenience for you. But welcome, Tony, Frank and Richard. This is very conversational. We want to pick your brains, we want to know your views, and we want your help. So I think possibly one of the best ways to proceed would be if you each wanted to make an opening statement and set out the scene of your own views. And if you'd care to do that, we'd be very interested then to ask you questions afterwards. Richard, would you like to start us off on that?
I'll make a very short opening statement, and it really comes to this, that the possession of power in society is inevitable. And without it, there cannot be government. Without it, there would be anarchy. So that's the core assumption. But an equal core assumption is that power tends to corrupt whoever holds power. For that reason, there has to be accountability, and accountability is in practice only likely to be achieved by some measure of checks and balances. In our society at the moment, there is an absence of clear checks and balances. This affects all organs of the state. In theory, at least, judges have potentially unlimited power, greater than is often supposed. The executive has enormous practical power and is in practice not effectively constrained by Parliament. But in theory, at least, Parliament has supreme and unlimited power. It is accountable to no other institution or organ of the state. Because power tends to corrupt, it follows that this state of affairs is unsatisfactory. But those possessing power will tend to have a vested interest in resisting fundamental changes to the way in which that power is constituted. Moreover, given that those possessing the most power, in fact, will have the most interest in preventing change, it follows that short of some constitutional crisis or highly persuasive reason that triggers a desire for change in those with the power to create it, such change will never happen. Given these facts, and these are really the 3 points that I want to central to what I want to say. One, it is highly desirable to codify our constitution, if by that is meant introducing a framework in writing for how we are to be governed. But two, such change will not come about through assertion, for example, banging the drum of democracy or particular policies. It will only come about by persuasion of those who hold power. So three, proposals for constitutional codification should be pragmatic, realistic and simple. They must also have an underlying reason driving them.
Thank you, Richard. Tony, would you like to make a...
Well, it's very kind of you to invite me. I have been interested in this over many years, and perhaps I might explain how my interest arose. In 1945, I came back from the war, and there was an election and I was not allowed to vote. They said you have to be 21. Well, I had been 3 years in the services and never killed anyone, I'm happy to say, but still I'd done my stint. And I was incensed by this, that didn't qualify me. Then, some years later, when my father died, I was disqualified from the House of Commons on the ground my blood had turned blue. And that interested me in the whole nature of our relationship. And then later, the referendum and the common market and the powers question, which is now very current in our discussion, they interested me in what might be done about that. So I tried my hand at drafting a new constitution, which was presented to the House of Commons, and I think a copy of the text of it is available if you wanted to have a look at it. But that's my approach, and I agree entirely with the points that's been made about the importance of accountability of power, because a Member of Parliament is employed by 60,000 people. It's the only job I know where you have one employee and 60,000 employers, and therefore in your constituency everybody you meet employs you. Bus drivers, street sweeper, home helps, district nurses. You're free to say what you like, but they're free to get rid of you if they want to, and that keeps you in touch with what they're thinking. And I think the most powerful form of accountability is through election democracy.
Tony, thank you. Frank?
Well, first of all, thank you very much for the invitation to be here. I just wanted to say something about the question of whether we actually need a constitution or a codification. And I think there are two kinds of relevant tests. One kind of test is whether the present arrangements actually do what we want them to do. For example, do they encourage participation, encourage people to get out to vote as a minimal form of participation? Do they engender respect or trust in Parliament, for example? Do they give people a sense of where they can go if they have a grievance, or do they feel powerlessness? So that's one kind of test one can apply. There's another kind of test about present arrangements, and that is, do they provide reassurance against people's fears? Now, people have different fears. Some people fear that we're passing powers to the European Union without proper consideration. Some people are afraid of the power of unelected officials, regulators, central banks. Some people are afraid about rights culture, giving rights which they don't agree with to immigrants or welfare recipients, whatever. So another category of question is, does it give that kind of reassurance so people feel comfortable with the arrangements? Now, I think you can go down a list of questions in each of these categories, each of these two categories, and if one did a score sheet at the end of it, I think we might score quite highly on some, but not on others. And I think the overall report would say could do much better. And I think that is why we need to consider a constitution or codification. But at the same time, we do need to recognise there are considerable obstacles, and at the end of the day, we might decide it's just all too difficult.
Just one question from me, just to help kick us off. Are we looking at codifying what is, or are we looking at codifying something that we would prefer to what is? And indeed, could we do both, in the sense of starting by writing down what we already have and then perhaps leaving it to evolution, Parliament or government, to have the debates about where we should move on from there? I don't know whether that's...
Well, my feeling about that question is that it depends upon what process is likely to be more persuasive to Parliament. There is great value in codifying what we have, great value, because apart from anything else, it would reveal the difficulty of codifying what we have. If such an exercise were to be undertaken, it would be necessary to be selective, and it would also be necessary to have some authoritative commentary, because there are huge differences of view between people you would expect to understand what should be in our constitution. There are judges who believe that the common law trumps parliamentary sovereignty. there are many who believe that parliamentary sovereignty remains the bedrock of our constitution. These differences would have to be elucidated, I think, in authoritative commentary to any attempted codification exercise. However, what I would hope that the committee would at least consider doing, apart from perhaps authorising some form of what I would describe as a low-key but independent codification exercise, which might not depend on parliamentary authority, is to focus upon the possibility of a very short either constitutional framework statement or a very short constitution which would have cross-party support but which would not in any way be anything more than a short document, persuasive to Parliament, and I can elaborate later perhaps on the arguments that one should use in order to persuade Parliament that such a document would be valuable.
Tony, any comment on codifying what we have or what we ought to have?
I think it has to be about what we prefer, because what we have is defective. And if it weren't defective, you wouldn't be having this committee now, and you've been set up on that basis. And the defects are very straightforward. We live in a modern parliamentary democracy, but the Crown powers have been retained, and they go right back to the coronation oath of William I in Christmas Day 1066, when he said he would govern the country. Now, if you look at all the powers associated with the Crown, not one of them are actually exercised by the Crown. They're all exercised by somebody else. I mean, the Queen doesn't summon Parliament, the Queen doesn't dissolve Parliament, the Queen doesn't write her speech, annual speech, the Queen doesn't enact legislation, and yet all our written laws imply that they do, and these powers have disappeared somewhere else. The Prime Minister, in effect, is now the unelected King, and he has access to all the powers. Parliament cannot discuss prerogative powers without the consent of the Crown. And so I think you would have to look for an improved system, and if you did that, I think the refreshment of that, so long as it's safeguarded and was designed to safeguard people's rights, would appeal to Parliament and to the public.
Frank?
Yes, I think it's going to be quite difficult to stop with codifying just what is, because I think the process of codification will inevitably raise questions. For example, if one's trying to codify the powers of the Prime Minister, almost inevitably perhaps questions will arise about how to structure those. So I think it's going to be very difficult to just stop with the codification exercise, even though one could perhaps treat the two parts of the exercise rather differently. I think also relevant to that is that there is a problem of the unsettled parts, where we know that things are going to change, and we wouldn't actually want to be codifying necessarily. For example, the question of the relationship between Scotland and the rest of the United Kingdom, the question of the role of the House of Lords. These are our relations with the EU. These are all arguably unsettled parts, and I think one would have to perhaps look for a statement of principle, perhaps what is the role of the House of Lords, to take that example, but leave quite a lot of the mechanics flexible as to how actually one would change the House of Lords. But I think that question of unsettled areas would have to be addressed as a specific problem area.
Stephen?
Perhaps if I could start with Mr. Benn. I've just been reading the Commonwealth as written bill, which is 19 years old now, and I just wonder, having flipped through, it's remarkable in a way how quite a lot of what was in your, what must have been a revolutionary statement in 1992 has actually now been implemented, although quite a bit is undone. It has not been done, rather. Are there any things in your bill that you now wish you hadn't put in your bill?
Well, I had to look up the bill.
Have you warmed the Queen?
Yes, I had to look it up to see if I disagreed. There are one or two things I would have added. I'm coming to the view now that if you have a true democracy, the Cabinet must be open to the press in the way that Parliament is. It sounds very radical, but if you listen to Hansard or read Hansard, you only get discussion. You don't actually get decision-making, except the votes tell you what the outcome is. But in the Cabinet there are real discussions of alternatives, and I think that would be a point I would add. That would be under the freedom of information provision, and so on. So if I went through it again, I probably could make changes, but otherwise, when I looked at the main drift of it, the English Parliament, the federal chamber to replace the House of Lords and so on, I think it makes a lot of sense.
And you still favour an English Parliament as a solution to the West Lothian question? You still favour an English Parliament as a solution to the West Lothian question?
Well, I think parliamentary government is the right way of doing it, but Parliament doesn't actually control many of the key decisions, which are still Crown powers, and that means there is an isolated part of power making in Britain, decision making in Britain, exempt completely from any form of democratic control.
You were ahead of your time on trying to reduce the voting age, which is something I tried myself to do 6 years ago and lost in a bill by just 8 votes. So hopefully in this Parliament that reduction to 16 will happen. But on the voting system itself, while your bill is quite revolutionary in terms of a major constitutional settlement, I think you're still wedded to first past the post. I just wonder how you square that with a more pluralist outlook about democracy.
Well, my opposition to the list system is that the people who sit in Parliament sit there at the decision of their own party leaders who decide where you are on the list. And I think every member of Parliament should be elected by the people, not chosen by their leader, which would enormously centralise power. But I am in favour and voted for the selective system 1, 2, 3, 4, 5, which I think gives greater force to the people. And
so you're in favour of single transferable votes, but not a proportional list system?
Well, the system of what do they call it, selective
STV.
The alternative vote.
Yes, STV, I think, is more democratic because it gives everybody the right to have a role in the final decision, which otherwise there wouldn't be. But it's not the same as voting for a party and your leader deciding whether you're worth putting in Parliament or not.
I wish we'd known that 9 months ago. I think we would have enlisted you in the Yes campaign for changing the voting system. I wonder, it's a joint question to Tony and to Richard, Professor Gordon, whether you've read each other's constitutions, because Richard's is much more up to date, and what you identified as the strengths or the weaknesses in each other's proposals.
Well, I did read Tony Benn's. Indeed, as I was saying to him earlier, it was one of the triggers for doing it myself. It seemed to me at the time that Tony's constitution was very brave and a bit like sort of space travel, not really foreseeable in the reasonably realistic future. Unhappily, having written my book and created my own constitution, I also think that that is not realistically achievable in the near future. And so my views have modified quite considerably in terms of what I think the best approach to getting constitutional reform is. But that's not to say that I don't believe in the proposals I put forward, or that I don't actually sympathise with a lot of Tony's proposals. Just to give one example, I share his views personally on the monarchy, but having done quite a lot of research amongst friends and colleagues and so forth, I was persuaded not to go as far as he did, but to invest the monarchy with a symbolic authority. But I do think, as I say, that there are great attractions to what he has done. If it was a blank slate, I think I'd possibly go as far as he has done.
Well, the phrase that sums up my objection in a way is the oath that bishops have to swear when they've been appointed. They say they're elected, but they are appointed because the Church of England is one of our oldest nationalised industries. They're appointed, and they then have to declare that Her Majesty is the only source of ecclesiastical, spiritual and temporal power. To be a bishop, you have to deny the whole existence of democracy. and that's the basis on which you get appointed. And this is not something that worries bishops very much, but when you look at it, it does tell you something about the Constitution, which identifies, I think, one of its defects.
Another question to Mr. Benn. Your solution to the monarchy was a president, but if I've interpreted correctly, as your bill was drafted at the time, it was an indirectly elected president. It was someone chosen from amongst members of the House of Commons and the House of the People would have replaced the House of Lords. Would you now favour a directly elected head of state rather than someone chosen from the...
I think the problem of a directly head of state is the problem, really, you get a conflict between two sources of authority.
Right.
Someone elected by the people, like an American president, would have a degree of authority that they could claim was greater than the authority of those in Parliament, who are large numbers and divided and so on. So I prefer the idea of a titular head of state. And strangely enough, if you're looking for a suitable titular head of state, I think the Speaker of the House of Commons would be perfect. He is elected by Parliament, he's respected, he understands the Constitution. And if you had him and a Prime Minister who was really accountable for what he did, I think that would be the best balance you could get.
Mr. Burke would be very pleased by that statement.
You finished, Stephen? Sheila.
I mean, I'd maybe like to turn to some of the kind of more practical things about how we would, what process we should put in place to start moving this whole debate forward. Because it's nice to sit and kind of draft alternative realities, but what do you see as being the things that would have to be done to at least get on the first step of this journey?
To my mind, it's self-evident that to get a constitution in this country, you have to persuade Parliament. Practically, you have to persuade the executive. You don't have to persuade, at the first stage, the people. And one has to be very careful what one means by democracy anyway. And I'll perhaps come back to that later. But I think there are reasons which could persuade Parliament to start the trajectory towards a written constitution, or at least a constitutional framework statement. The first point is that this country is sitting, in some ways, without wanting to express it too dramatically, on a potential power conflict between the judiciary and the executive. The reason for that is that as parliamentary sovereignty as an idea becomes more difficult to apply practically, so for example, the increasing power of the European Union, it is important, I think, that boundaries are set between the different organs of state. And I think that Parliament would be persuadable that with a written constitution, albeit I think quite a limited one, judicial power could be curtailed in a way that left no doubt at all that Parliament was the supreme body in the state. I also think, contrary to views that have been expressed by some MPs, that it's only having a written constitution that will enable this country to resist the increasing power of Europe. I mean, it should be remembered that in Germany, it was the German Constitutional Court in a case called Solange which resisted the so-called idea of European uniformity, supremacy. And because it clashed with Europe, Europe eventually introduced fundamental rights into its legal order. And the third area where I think Parliament will be persuadable is that even those in the executive are uneasy about not knowing where the boundary lines are. It's okay when you're in power, but you're not always in power. This is the point. And so there is, I think, a feeling that it would be desirable to have some clearer boundary lines about how far the executive can go. If you had all this in a very simple framework document, whether you call it a constitution or a framework statement, I think there is a chance, a realistic prospect of getting it through.
Can I just follow up before the others come in on the question of the judiciary?
Yeah.
Because I think my recollection of having done sort of constitutional law and history a bit was always the feeling that if you had a written constitution, you had more, more judicial involvement, because you now had a constitution which could be interpreted or argued about.
It's not correct. I understand the view, but there is a myth, I think, that because judges interpret a constitution, they can interpret it any way they like. This has been proved, the limitations of that have been proved with the Human Rights Act, for example. I know there are complaints about the way it's interpreted, but the one thing Parliament has ensured through its drafting is that an Act of Parliament survives intact with full authority, no matter how the judges interpret it. Now, you could tighten that model in a written constitution. You could have very clear drafting which would prevent judges from interpreting black as white. The American Constitution is not a good precedent, because those who remember the case of Marbury and Madison will realize that the American Supreme Court's power to invalidate legislation came from its interpretation of its powers. But that could be prevented in a carefully drafted constitution. What can't be prevented if you don't have a constitution is creeping judicial supremacy by an assertion of the untrammeled nature of the common law. This has already happened in recent case law. Both Lord Steyne and Lord Hope in the Hunting case, Parliament Act case, both said, completely inaccurately in my view, but they both said it, and once it's said it acquires legitimacy, that parliamentary sovereignty came from the judges. Now, you only have to look at the report to see that what I'm saying is accurate. That's what they said. And once judges start saying these kinds of things, they acquire legitimacy, because precedent is quite dense and cumulative. And I do see, without a constitution limiting the powers of the judges, a real danger that there may come a Marbury and Madison moment, as it's been put in some of the constitutional books, in which judges will gradually, we've now got the Supreme Court. It's by no means unthinkable that judges will seek more power. I think that would be anathema to Parliament. I think it's therefore a good argument for starting on the road to a written constitution.
The others want to say something about the practical steps we should take if we want to start down this road?
Well, first of all, obviously this committee itself can do enormously useful work in preparing the ground and clearing away some of the undergrowth. But I think eventually one would probably need a slightly different two-step procedure, a committee of experts who would define and refine the issues as perceived by this committee and prepare some alternatives to the problems which the committee sees. And then it would have to be overseen by some kind of cross-parliamentary group, because it's not something where the parliamentary group would have to be able to give guidance, say we want more on that, or we want less on that, or don't go up that blind alley, or whatever it is. So I think that kind of procedure would ultimately be necessary. But I think we have to be aware that there are three very practical obstacles. First of all, the institutions have their own vested interests. We saw that in the case of the EU Lisbon Treaty. And therefore, the institutions have to, in some ways, be kept at bay. Secondly, civil society is a problem, because there's the problem of the advocacy organisations, the NGOs. They have axes to grind, and therefore that's a problem. And I think, with all due respect to my neighbour on my right, lawyers are a problem, because they do tend to think of judiciable rights and a judiciable final arbiter. And I would think that the way of incorporating legal expertise is for a cross-parliamentary body to have lawyers as an advisory group. I would not particularly put them, or civil society organisations such as the Civil Liberties Group, I would not put them on the expert group. I would look at not only political scientists or economists on the expert group, but also sociologists and social psychologists. Because at the end of the day, if we're going to move towards a written constitution, it has to be salient to people. If it's not salient, it's not worth having. So your target audience is not a civil libertarian geek, it's the working mother who is multitasking. If it doesn't make sense to her, forget it.
And before I ask Tony to come in, Frank, your view of the Scottish Convention ahead of the devolved settlement in Scotland? Do you think that was a good model and perhaps a transferable model?
I think the way of soliciting a wide range of public opinion is to go the town hall route, which has been tried, I think, most of all in the United States, as a political device of reaching out to the grassroots. I prefer that to the convention model. And I think one can use postcode systems to enable people in the locality to log in to the debates being held in a town hall if they don't want to, and intervene or monitor the debate on their iPads, whatever. I think the town hall model, which also has quite a theoretical literature history behind it, is the way to go.
And Stephen, just on that point?
This is a supplementary on that, maybe to all three. The town hall model is fine, but Iceland recently has had this citizens' convention of 950 people drawn randomly from the population, so it really is a bottom-up process, whereas your two fellow witnesses essentially have laid down tablets of stone from parliamentary Mount Sinai or the legal Mount Sinai. Which would you prefer?
I prefer the random because it has to be grassroots, it has to make sense to the grassroots. I'm not particularly keen on the random, but I would prefer it. But I think it's a way, I would look for a way of linking an expert and a parliamentary oversight system to a grassroots, and I think the town hall way is the way of going.
Tony, sorry to have kept you waiting, but any comments on process? How you get from here to codification?
I think the thing that is going to make this important in the public mind is our relations with the world at large. I mean, the European example is one, but the IMF, which we don't elect, has enormous power. The central bank in Frankfurt has enormous power. We don't elect it. And I think at some stage people are going to ask themselves, to what extent does this infringe upon our claim to be self-governing? And that is the referendum argument, of course. And therefore that's the way it will come about. And it may be that the whole thing won't come out as a perfect constitution, but defects or problems that arise will be seen to be capable of being dealt with by amendments to our law here. And when that does take place, people will see that's part of our new constitution. It's a very messy way of doing it, but all progress has always been made in that way. It's never going down to start at the bottom and write it all up perfectly. It's always been dealing with an immediate problem that has to be dealt with.
Sheila?
The experience of Scotland in some ways is quite interesting, because if the end that we're all trying to achieve, or one of the ends, it's not the only end, if one of the ends is to kind of make both the constitution and politics more relevant to people, the Scottish example, while we had the convention, there was a large degree of sign-up, maybe it wasn't exactly grassroots, but certainly a large degree of sign-up, changed the model in lots of ways from the Westminster model, including the voting system. And one of the outcomes has been that fewer people participate if you measure that in terms of voting, since that is the opportunity that ordinary people have. Significantly fewer people vote than in, for example, the Westminster election. So neither changing the voting system to STV, well, it wasn't STV, but it's to a proportional system, nor necessarily having a body that is different and apparently more. People spend a lot of time thinking about how it would process legislation and so on. Is all this really just not something that resonates with people? Is this just not what they're interested in?
Well, what happened in Scotland was the result of a demand, and the demand led to a partial success, greater powers, and then a new development, or new developments are occurring, and people are taking them on board, accepting them as normal or rejecting them, looking forward to the next stage. And that's what I rather meant when I said all change takes place on a case-by-case basis rather than a perfect model at the end, and how the outcome, what Scotland will be like in 100 years' time, will depend on the Scottish people. It won't depend on the English. It'll depend on the Scottish people, and you will have worked out how you want it to go, and if you decide on a new format, it will take place and will then be the constitution you accept and respect.
But in terms of, people don't seem necessarily to be that engaged.
Well, they'll have to be engaged, won't they? Because questions will arise they'll have to vote upon.
I think there are a number of reasons why people don't vote, but I think one of them is they feel it doesn't matter, they can't influence anything, they are powerless. And that can overcome or supervene on changing a voting arrangement. They just think that it doesn't matter, whatever voting system you have, they can't influence the system, it's not going to be responsive to them, then you have a different type of problem. And I think that's what's happening to some extent in the UK today. You have powers spread between different regions in the United Kingdom, and then you have the European Union, of course. And people probably feel very disconnected with the way power is actually being wielded. When I first favoured 20 years ago in my IEA paper the idea of a written constitution, it was because I felt that the EU is a problem. Powers were being transferred there, and I didn't feel that we were intervening sufficiently or thinking about it in the right sort of way to grapple with that particular issue. And I think today what we see is people not very comfortable, not at all comfortable with our relationship with the European Union. And I think that creates a very unhealthy relationship between people who are uncomfortable and political leadership who says we have to get on with it, there's no alternative. I think that's a very unhealthy situation, and I think that we would have provided better safeguards in our dealings with the EU if we had thought constitutionally. And the kind of constitutional safeguards we have in the EU treaties are things like subsidiarity, the principle of conferral of powers, the yellow card system. None of these work. They don't work because there are too many loopholes in the principle of conferral. There's too much emphasis on harmonisation. We've failed to recognise that three of the institutions, the Commission, the Parliament and the Court of Justice, have a vested interest in extending the powers of the European Union. And we've failed to recognise what is called a blocking minority when it comes to voting is not a blocking minority, it's a bargaining chip. We get something, but we have to give away something. So we need a much more flexible kind of European Union and relationship with the European Union, and I think we would have had a much more flexible union if we had thought constitutionally about these kinds of issues.
Perhaps this is a moment for Christopher. I think I've finished my question.
Okay.
So.
Did you want to come in particular on the back of that, Christopher?
Well, I agree with what Frank said about all the problems with the European Union. But surely the answer to those problems is not to have got into the position where we are already. We could have stayed outside the European Union. We could have avoided the salami slicing of our sovereignty, which has occurred over successive EU treaties, and we wouldn't be in the problem we are. I don't believe that if we had a written constitution, it would have prevented this any more than having a written constitution in Europe, which we thought we'd signed up to in the Lisbon Treaty, has actually prevented the abuse of concepts like subsidiarity, which was exemplified yesterday in the statement on the Common European Sales Law, which made it quite plain as pikestaff that although the government and this Parliament thinks that this Common European Sales Law is in breach of the subsidiarity rules, it's not going to make a ha'porth of difference, because in order for even the European Commission or Parliament to look at it again, they need to get 1/3 of all the chambers of all the parliaments in the 27 member states to agree with us that there's an issue to be discussed. So, and that just shows the extent to which our sovereignty as a nation has been eroded by these European treaties. And surely the answer to the problems you may raise is to have a referendum of the people now, coupled with proper information as to the costs and benefits, to see whether the people would now wish, having had the experience of being in the European Union, to go back to having a pure trading relationship with our European partners.
Well, with due respect, I don't entirely agree with that. I think to pose it as an inside or outside the European Union question is actually a misperception, because whether we're inside or outside, we're going to have a structured relationship of some sort. The EU has a structured relationship with all its neighbours, and we would be in the same situation of wanting some kind of structured relationship, and the EU from its side would want some kind of structured relationship. So the question is, how do you get the right kind of structured relationship? And that's where you have to start thinking constitutionally.
Chairman, who's going to interpret this structured relationship? That's
a different issue.
Heart of this problem. Because if you have an unwritten and evolving constitution, which is what we've got at the moment, then it means that you're not confronted with the problem of having effectively a freeze-frame constitution, which is brought in at a particular time. It might have been Tony Benn's constitution written down, but that itself would have needed to be amended to reflect changing situations. And even Tony's own evidence at the beginning said, well, when he started off, he was against having the voting age at 21. Well, it came down as a result of consensus, and the views of Parliament came down to 18. Again, the hereditary peerages. That was altered by Parliament to reflect a different view within the country and a different view amongst the country's elected representatives. Similarly, at the time of Ted Heath and going into the common market.
Is there a question there, Chris?
Yes, this is a question, because basically what wouldn't the witnesses collectively agree that they have demonstrated in their opening remarks that the problems associated with inflexibility that inevitably goes with having a codified or written constitution? Isn't it better to keep things flexible?
And I will come back to Chris, but Eleanor's next. But if the witnesses would like to just respond quickly to that.
I'll just very quickly respond to that. I think there's a huge difference which has yet to be articulated between policies which are capable of change and constitutional concepts which are less capable of change but are also capable of change. So the idea that the voting age is some form of necessary constitutional provision, I think needs to be treated with care. I think that there are what resonated with me was Frank's comment that one should think constitutionally. I actually agree that if we had thought constitutionally, it is possible that we would never have entered the European Union in the first place. So thinking constitutionally has its benefits as well as its drawbacks. I would, however, very quickly simply say that we should not leave. We should always come back and back to this question of process. I agree, it should be cross-party support, the most neutral statement of constitutional provisions possible to get broad cross-party support. And I certainly would suggest you can't exclude and shouldn't exclude lawyers from that process. You should involve all the major players of state. I actually think there's a huge need for lawyers and politicians to understand each other better. And that I could develop later. But essentially, the process has to be simple. And if it gets us into arguments about Europe or voting age, the whole focus will go. It's got to be very, very simple and very clear.
I think on this rigidity question, there are two different issues. One is the judicial review issue, and there I think there are alternatives to consider. But on rigidity, I think again it's a slightly false proposition. Any constitution is going to have a mix of soft rules and hard rules, and it needs both kinds. Hard rules are things such as anyone accused of something has a right to a fair trial. That's a hard rule. The soft rule is, for example, the Chancellor of the Exchequer telling the Governor of the Bank of England that these are your public policy objectives, but leaves open as to how the Chancellor sets those. So a constitution will deal with both kinds of rules. So that's the issue about rigidity.
You see, the common market is only one of examples of international relations. The United Nations is another, and that has enormous powers. And with the criminal court in The Hague, which could affect our people, that could have become a burning issue, but it hasn't. And I think we have to approach this in terms of our own experience of what's happening, whether we like it or not, and if we don't like it, how we would change it. And then if we change it, that fits into an evolving constitution rather than one that comes freshly drafted out of the lawyer's mind.
We will come back to you, Chris, because I think this is a real, it's an issue, the European issue focuses, would a written constitution be helpful to those who are trying to safeguard some form of national sovereignty or parliamentary sovereignty, or would it be unhelpful? And I think it's very, very important. Very briefly, it would, to me, appear that in this country we have very, very strong executive authority, untrammelled by a written constitution, and it has been that executive authority that has led to the movement of power without effective check in this country. And arguably, had we had more effective check and had Parliament not been towed along by various executive governments, we could have actually stopped some of the things or made them more legitimate if we'd had some sort of written settlement. And I'd like to come back to you with that, with some of those views, because I think this whole concept of it's either Europe tell us what to do or we have parliamentary sovereignty, I think is a totally mythical one. I think the problem here is executive power. But let's come back to that, because it's a big issue which focuses a lot of our thinking. Ellen.
Yeah, thank you, Mr. Chairman. It's exactly that I would like to approach from a slightly different aspect, but not very different, because I think you have summed it up there, the crux of our discussion. And it's interesting to note that Tony mentioned three things which set you off originally on this pilgrimage, and 2 out of 3 isn't bad. You have succeeded, or you and many colleagues have succeeded in reducing the voting age from 21 to 18. Our system has succeeded in dealing at least partially with the hereditary peerage, and there's every prospect of the hereditary peerage generally being dealt with over the next year or so, which leaves the third one, so there's still hope of you getting 3 out of 3. Bingo, eventually, as far as our relationship with Europe is concerned. And I wondered if I could ask each of you, when looking at the structured relationship that we perhaps ought to have with Europe, is it relevant that every other country in Europe, and indeed wider, has had some form of structured constitutional renewal as a result of war or revolution or uprising or something in the last 150 years, and the United Kingdom is almost unique in having had no examination of our constitutional position in 2 centuries? Is it relevant that other countries have therefore more modern and custom-made constitutional arrangements?
Well, if you look at the Arab world today, I mean, what interests me about Egypt is it's so much like our own history, great opposition to repression, you topple the government, and then you find what you've got is military, so you come back and you raise it again. This is the English Revolution and Cromwell and so on, exact parallel. And that's how things do change. Now, we've had a number of substantial changes, mainly as a result of industrial development, I think, which have had an impact on the way our constitution has developed. The one thing we haven't done is to inscribe the rights of citizens. There is no way where you can look and see what your rights are. We have duties, most of which are completely illusory, but we have duties imposed on us, but we don't have rights conferred upon us. And I think there could be a lot of dissatisfaction around that. I mean, the common market question is just one example, if you like. Can a government subordinate you to another legislature abroad or not? That does raise questions of human rights. And maybe that's how things do change. But you're quite right, we have not been through a revolution or a war of a kind that forced people to sit down with a pencil and paper and start from scratch.
You asked if it was relevant whether most countries who have written constitutions have had their constitutional moment, i.e. a crisis.
Yes.
It's plainly relevant because it is almost impossible to think of any country that hasn't had a constitutional moment which has created a constitution.
Yep.
But the next question, which I think has to be asked as a supplementary, is why is it relevant? And the reason I think it's relevant is that we do not think those with vested power interests are not the ones who are going to propel or trigger change. And that's why it takes a crisis. It took a crisis in Iceland, for example, to get them moving on their constitution. But I would prefer to avoid the crisis. And you avoid the crisis by thinking, to use Frank's graphic phrase, constitutional thinking. And if we fail to think constitutionally, we're not going to anticipate crises ahead. I mean, this government never anticipated for a minute when Blair wrote on the back of an envelope having a Supreme Court. He didn't think what that would entail or could entail. When he proposed reform for the Lords, he never thought that this could present the impasse it has. And to my mind, there will be further crises along the road which we simply can't even foresee today without a written constitution of some sort, and without us thinking as a nation constitutionally. So, yes, you're right to say, in precedent terms, it's very hard to find a country that hasn't created a new constitution out of crisis. But that's not a reason for not having it, it's actually a reason for having it.
I think if one goes back to this question of the constitutional moment, there are three potential triggers. One is an external shock. Soviets leave Central Europe, people have to draft a constitution. Another is an internal crisis, the Arab Spring has been mentioned, a perfect example. The other situation is the one which was discussed by Nobel Prize winner James Buchanan in the constitutional economics literature. And in his view, you get a constitutional moment when you have a transfer of powers within a multi-level system. And that's what we're having now with the regions and with Europe. And in his view, when you get that kind of shifting of powers within a multi-level system, you're going to have a constitutional moment, because when you shift powers, you need safeguards and over the exercise and the definition of those powers. So the question is, why haven't we had this constitutional moment when we're seeing lots of powers shifting around? And I think this does get back to the point made by the chairman, that this has been done by the executives. And so we've essentially had an abuse of executive power, and this has stopped us from having a constitutional moment.
Very good question on this. It's fascinating.
Thank you. Can we explore the next step? If it is relevant, and you have all said that it is relevant, that our European partners have different constitutional structures to ours, would our country, and I'm using that term so we don't have to go into, do we mean the United Kingdom, do we mean Great Britain, do we mean England, do we mean Scotland, generally, would our country, our people, be better protected, since Frank said that the current safeguards don't work, and I take your point there, would we be better protected if we had a constitutional structure which made us fit in? But no, let me not put it that way. That would be a leading question, Chairman. Let me put it the other way around. If we had a constitutional structure and some kind of codification of our relationship with the European Union. And what I'm getting at here is, we discovered as a committee when we went to Dublin a few weeks ago, and we were discussing constitutional arrangements in Ireland, that of course Ireland has a constitution which was written in the early part of the 20th century and has inbuilt, for example, the need for a referendum at certain key points. We don't have that in the United Kingdom because we don't have a modern constitution, and that has protected Ireland. And Sheila was talking about engaging people in the constitution, the people generally in the constitutional discussion. And it's all about whether we should have a referendum or not. Of course, we don't require to have a referendum on anything because we don't have a constitutional structure. Almost every other country does, and it's noticeable when you look at Ireland with a modern constitution that there is a protection there. It's also sometimes a break, which can be frustrating to the executive who want to get on with things. But would we have? Sorry, I come to the question, but I wanted to leave it wide because I think we might get some interesting answers. Would we be better safeguarded through having a written constitution?
Well, that question can be slightly reframed. Would we be better safeguarded if we had constitutional safeguards? To which the answer, to my mind, is self-evidently yes. Depends what safeguards, but you mentioned the referendum, which is not a bad way of engaging periodic review by the people, however that's done. But would we be better off with carefully framed, clear, accessible constitutional safeguards? I can't see how that question could be answered by anything other than plainly. Anyone who's read de Tocqueville's L'Ancien Régime will realise that change after the crisis has happened is too late. I mean, existing structures, if we have this sort of third model which Frank has mentioned, shifts of power vertically, horizontally, we don't see the crisis until it's happened. And once you start replacing things after that, it's a much less planned and structured constitutional framework than you would have had if you'd acted in time. So that's broadly my approach to that question.
Well, our constitution is developed as a result of meeting local needs that hadn't been thought of before. I mean, for example, in the year 1832, which is not so very far away, only 2% of the population had the vote. No women, of course, and only 2% of the men. And the struggle for the franchise was in response to growing demands from people who felt excluded. And so that then, as it came in, became part of our constitution. And I think that that is the way it always happens. Society learns by its own experience and then tries to deal with it by legislative provisions, and then when they are integrated in with the other legislative provisions, becomes part of our developing constitution. Now maybe in the course of that there is a case for sitting down and writing and publishing a completely new constitution that would deal with all these problems. Whether people will be as interested in that, I'm not so sure, but it's of enormous importance that it be done, because unless people feel they have a legal stake in society, they won't take an interest in the way they should in the politics. So I think that is the way to do it, and that's why I think the proposal by the committee to look at a written constitution is a very important one.
Richard has mentioned the German constitutional case, and I think it has had an unexpected effect. The result of the Karlsruhe judgments on two occasions now, I think, the unexpected effect has been to strengthen the role of the Bundestag, and specifically the European Committee in the Bundestag, because the court has said that powers can't be passed to the Union unless the Bundestag has agreed. And this has strengthened the role of the European Committee in the Parliament, and we've seen it very recently, where effectively the Irish budget has had to be approved by the European Committee of the German Bundestag before the German Chancellor feels free to give it assent. Now, that's a result of constitutionalism. I'm not sure that I would entirely commend it, because I'm not so keen on a final judgment being made by a court, by a judicial process. But nevertheless, this is one example of how having a constitution actually alters things, and I think it alters them in a rather unexpected way.
Can I have one tiny last question? Just a very, very quick last question, because I think we've been exploring some very important matters here. Would it be correct to say, as Richard said in referring to recent changes in the bringing in of the Supreme Court, of proposed changes to the second chamber, the House of Lords, the creation of the Scottish Parliament, the Welsh Parliament,
would it be correct to say that you cannot, that a government cannot change a part of the Constitution without affecting the whole Constitution?
Well, that's an equally profound question, if I may say so. The answer is, well, first of all, you will be pleased to know that Lord Newburgh, the current Master of the Rolls, said that you can't tinker with the Constitution at your peril. But the answer to that really is that the problem you've identified, i.e. you can't move one prop without the thing collapsing, that's perhaps the logic of the question, is that this is a very great danger that arises from untrammelled executive power. All the various constitutional dramatic changes that you've referred to are the result of executive fiat, essentially. They're not the result of a constitutional framework which would govern the progressive, principled change that I think we would all advocate. And so, yes, I think there is a point to be made that you tinker with the whole, you tinker with parts of it at your peril, but that's exactly what the executive is doing, which is why we need something which approaches the thing holistically, but does it in a very low-key, neutral, minimalist way, in writing, by consent. I mean, I can't think of any other solution to this, because once one starts getting into areas of policy or getting into areas of disagreement, it's never going to happen.
Tony or Frank on that?
Well, I think one can take a discrete area, but recognise there's a context and a wider context. And the example I would give would be of fiscal rules, budget rules. And one could think in the United States of the push at one point to have a balanced budget amendment as a way of maintaining fiscal discipline in the United States, and having that as an amendment to the Constitution. In fact, it's not been passed, and I think the momentum behind it has somewhat evaporated, and I think it's interesting to reflect on why. It's partly because it may not be respected in practice, politics may supervene. It's very difficult to formulate because you have to think about the entire economic cycle, and you have loopholes. You create incentives for people to avoid the fiscal straitjacket, and so they start thinking about guarantees or insurance or pooling, other ways of getting round such an amendment. So these are the sort of very precise issues one has to focus on in thinking about that kind of rule, but they can be looked at discreetly. But the context, of course, is the role of the executive and the legislative, and is one taking away from their functions. So what one has in the United States is the creation of the OMB in the executive branch, the office of the Congressional Budget Office for the legislative branch, and to address the political problem, recently it was a super committee. So you've not had a constitutional change, but you've had a rather focused discussion on a particular part of the Constitution, and it has had constitutional effects.
Just one of the things I would take from Eleanor's line of questions is clarity. Who does what? And I think there'll never be perfect clarity, and there will always be some room for interpretation, and that's quite appropriate. But in our context, would you agree there's very little clarity? We sometimes have a parliament that wishes to delve into whether traffic wardens can have particular powers on our high streets at one level, and pretends that it has a view that's taken seriously on global issues or the European Union, and seems somewhat to contain every level of power, and actually probably no real level of power. And defining what a parliament should do, defining what the localities should do, and defining above all what the executive should do, starts to bring into question then, into focus rather, some of these bigger questions about the relationships in a plural democracy.
There can only be one reason for not clarifying, and that is it's better to play this game of bluff. As Stephen Sedley once said extrajudicially, I wouldn't want to blink first if there was a conflict between the judges and the executive. But there isn't a need, to my mind, to play that game of poker. You need to have clear rules. It should not be divisive in the current state of our constitutional evolution that parliamentary sovereignty is the basic doctrine. But it equally should not be controversial that judges do have some checks over that, but they don't have unlimited checks. I mean, the growth of the common law is a very good example of lack of clarity, which has led to, I think, a potential crisis. Common law was only one of 4 or 5 systems of law in the sort of 13th, 14th centuries. And it grew. It grew because of politics amongst the judges. It grew to the point where the common law usurped all the other areas and is now seen by many people as the fount of our constitution. Now, that may surprise you, but it's true. And it does.
I was really raising my eyebrows as a Scots lawyer, not being wedded to the common law as those.
All right,
in
but it may be different
Sorry.
in Scotland. But the fact remains that it's not a good thing, lack of clarity. It's a very, very bad thing. And so, yes, I would agree with that.
Frank, Tony, any view on that? No. In a sense, talking about the moment, when the moment arises, there might have been that moment, although it came and went, when there was a devolved settlement. But in probably the first year of the Labour government in 1997, devolution to Wales, Scotland, there was some settlement around the Northern Ireland issue, and then a failure on the English regions. Had there been a consolidation of non-Westminster power at a lower level, if I can put it that way, that might have brought into pretty stark relief what it was, the Westminster Parliament, in effect the federal Parliament in the UK, would have had to have done. And that would then have begged questions about what our appropriate relationship might have been with the European Union and other international institutions.
About the sovereignty of Parliament, which we often speak about. I believe in the sovereignty of the people, and that is a higher order of sovereignty, because the people can lend power to Parliament for a period and then take it back again. And I think one should always see whatever you propose in terms of the impact it has on the rights of ordinary people to band together and achieve anything. And if that were to be restricted in any way, that might be convenient for Parliament, but it wouldn't really provide for a safe framework for the future development of society. So that would be the test I would apply, and I think it's always worth remembering. Parliament is a derivative of popular sovereignty and not its superior.
And following on from that, that's why we have this principle that no Parliament combines its successors. That's the essence of the sovereignty, because the sovereignty is coming from the people, and one group of people can't lay down the law and say, well, that's going to be the law for a future generation. It's got to be for that generation to decide for itself. And when Frank gives the example of what's happening in the Bundestag, that is actually quite the reverse of this, because what's happening there is that the court in Germany is saying, well, you need to have, if you're going to transfer sovereignty, then it's got to be done with the approval of Parliament. But once it's been transferred, it's gone forever. They can't get it back. What we want in this country is to be able to have a continual reassessment by the people, through the people's representatives, of what we want and what we don't want to be our laws. And that's the difference between, in a sense, the common law tradition in England and the continental tradition, which is very much more prescriptive. And okay, they've got these rules set out in Germany, but it's an illusion to think that those rules are always operating in favour of the people, because once one generation has given up power to the EU, then it's impossible to gain it back under the German constitution.
That's absolutely right. I mean, the Council of Ministers, which make the laws in Europe, first of all, they're appointed and not elected. And secondly, when they make a law, that becomes the law of Europe. And unless you can get back and alter the opinions of all of them, for which there's no process, you're stuck with what's been decided by an earlier Council of Ministers.
I think this is taking us to the question of entrenchment, isn't it? And Sorry, did you want to say something?
No, please go ahead, Richard.
Go ahead.
Well, there isn't an inconsistency between rules in the Constitution and the right of the people to review the Constitution, if in truth, the Constitution is an emanation of parliamentary sovereignty. And so the constitutional theory would be, correct constitutional theory, that Parliament can always review that Constitution. It would be entrenched in an Act only, and an Act of Parliament, by definition, can be repealed. However, there is a model which is worth mentioning, which is the legitimacy model, which we have in the Human Rights Act. The Human Rights Act could be repealed tomorrow, but gradually it has acquired a legitimacy which makes it more difficult than an ordinary Act of Parliament to repeal, but certainly not constitutionally impossible to repeal. And if we had a written constitution of the kind that I think everybody in this room is at least envisaging as a possibility, it would be one which could be repealed. I mean, it would not be one in which the values of the Constitution were permanently entrenched, but it would over the years acquire a legitimacy. And it's that legitimacy that I think is missing from our current constitutional arrangements.
Okay, and I think I'll call Simon, but I think we need to know what the landscape is in front of us, and we need to be honest about that landscape. And I think we need to challenge things such as one parliament can't bind another. In my long experience in the House, it's not been parliaments that bind or don't bind, it's been executive power using the mythology and the illusion of parliamentary sovereignty to create certainly laws that don't bind its successor. I, as you, Chris, have seen a procession of executives using Parliament to pass laws rather than Parliament itself independently, separately, with checks and balances, able to intervene effectively as an independent institution in that process. And I think let me just finish. And that's why I think the European argument might be the moment that some of the witnesses referred to, because it will reveal to all of us the full extent of unconstrained executive power, which can take us in, can take us out. Mr. Cameron can sit down and do a deal this week about treaty change, and you may want to organise some guerrilla warfare about that, but that actually is very different from a concept of parliamentary sovereignty. Please do.
But just take an example of, you say it's unchanneled executive power. What happened when we had the poll tax riots, so-called? The people spoke, and the people's representatives were concerned, and the executive reacted incredibly quickly to actually change primary legislation, thereby reversing what had been a major plank of the manifesto of the previous election. And it also resulted in, arguably, in the downfall of the Prime Minister of the time. So that came from the people, and it didn't. So I think it's wrong to suggest that it's all in the control of the executive.
Not Parliament.
Well, it came through
amendment
Parliament.
by riot.
No, it wasn't. It was ultimately you can say that it was Conservative members of Parliament who made it quite clear that they needed to have a change in the law. Otherwise, they were going to effectively be voted out by the people of the next election.
It was the electors' respawn, wasn't it?
Let me get back to the plot. Simon. And we'll come back to Chris, because there's some good stuff here.
Just going back a couple of steps. Richard, one of the sort of themes underpinning your written evidence was the restoring public trust and confidence in politics. And what I'm not sure we've absolutely got to is how this process not only engages the public, I don't mean the sort of those with a sort of intellectual interest, but genuinely engages a sort of public debate as we proceed on the one hand, and how at the end of it necessarily results in greater confidence. Because the reason I say that is actually taking one aspect of Tony Benn's proposals about devolved parliaments in Wales as an example. We have a Welsh Assembly, as you know. Okay, it doesn't have much by way of primary lawmaking powers, but there is no evidence whatsoever that the creation of the Welsh Assembly has actually done anything at all for public confidence in the political system. So it's a practical question, really, is to how do we engage people, why do we think it would work, and what your view is, or the panel's view, I should say, on the state of devolution, in my case, in the Welsh Assembly, and whether that has gone any way at all to achieving the objectives that you've set yourselves.
Well, I think, Simon, the first point about devolution is that, again, didn't come from a carefully structured constitutional framework. I do think, but you've anticipated, I think, another topic, which is how are the people going to be involved, even if the process is top-down? I mean, the reason I think the process has to be top-down is not through any belief that that is the most democratic way of doing it. I just think that it's inevitable that unless you get those with vested interest in power persuaded, you're not going to get any change at all. Now, once you've got, by a process that could be quite simply devised, I mean, it could even start with select committees taking evidence, producing a document and so on, endorsed by Parliament. I think, however convenient it might be, to avoid even engaging the people to get this document out, I think would be constitutionally illegitimate to do that. So you've got to involve the people in a decision. And this was Dicey's great view about the referendum. When Home Rule was being introduced, he added the referendum as an additional aspect of government to parliamentary sovereignty. It's an additional aspect of our constitution, in Dicey's view. The people's veto is very important. Now, I appreciate that we're a long way, I think, and this is one of the problems we have with localism, but we're a long way from the public, the general public, being sufficiently well-versed in constitutional matters to get really engaged. I think that as much engagement as possible should be tried. But rather like Tony Benn, I think that the way change occurs is not generally by the people deciding that there shall be change. I think that people should have the right to veto a draft constitution. If they did veto it, it's for consideration what the percentage might be, but if they did veto it, that would prevent such a document from coming into force. But obviously the process involved has to take account of the fact, this is one of the problems I hit me when I was drafting my constitution. You can't draft a constitution by popular vote. Statistical democracy has built-in tyranny. Minority interests, human rights have to be protected, as Tony Benn said. That can only come, actually, ultimately, from a process which begins at the top. If it starts at the bottom and you have a huge vote for hanging, is that going to go in the Constitution? Answer no. Because, ultimately, a constitution has to be informed by Western liberal democratic values which are pluralistic rather than statistical. So that's my rather convoluted response.
But I can imagine one reform which has been mentioned about equality of representation between the sexes becoming of such interest that it could come, if women demanded it strongly enough and a lot of men would support it, we would end up with a parliament, half of whom are women, and that would transform the nature of Parliament and the way in which it operated on a whole range of matters. So I think that could be an example of popular movement changing opinion at the top. However reluctantly the guys at the top had to accept it. I think they would have to accept it in the end because the basis of representation is sexist.
Just a quick follow-up really on the referendum point, because you mentioned earlier on that referendum did to some extent act as a safeguard. And I'm just, again, having gone through a couple of these in Wales in recent months, wondered the extent to which they really can, given the timing and the question and the sort of campaigning background noise is often in the gift of either wealthy lobby groups or indeed the government of the day. I suspect it's better than nothing, but in its current form, is it the safeguard that we'd like to think it is? How could we improve that? And do you, as a group, actually think that thresholds we've discussed thresholds around in this room before in another context. Actually, a good thing, of course, the creation of the Welsh Assembly was based on the vote of a relatively small number of people, and whether that's rankled ever since. I would be interested in your views.
Well, I think that, and slightly picking up what Tony Benn said as well, I think that if a draft constitution, if you start from the process, coming back to process all the time, it has to be cross-party. So that's why you don't get the campaigning. You won't get the campaigning, at least from the parties, and that really is important because the AV precedent is a really good example of how negative a referendum can be. But if you have a cross-party support for a constitution which has the sort of values that would excite the population, I mean, generally, AV proportional representation might be a turn-off, but 50-50 women-men wouldn't be a turn-off. I think you would engage the people with sufficiently innovative proposals, provided they had cross-party support. If you don't get cross-party support, my own belief is none of this is going to happen. And so we don't get back to the question of how weak a referendum would be. I agree with you about devolution, by the way, but my point about devolution in Wales, or indeed even in Scotland, where you've had to have the Calman inquiry quite recently, is that these were the brainchilds of a government that was entering into political compromises in order. It wasn't a constitutional programme. So going back to Graham's point, there never was a plan to introduce devolution, Human Rights Act. These are Supreme Court. These things sort of evolved from executive fiat again. So we're always back to these problems, I think.
Well, I would have thought most change of the kind we've been discussing was very controversial, far from being by all party agreement. I mean, if you take the extension of the franchise, the votes for women, and a whole range of other things, the NHS and so on, were very, very controversial. But my analysis of how change occurs is if somebody comes up with a new idea, to begin with it's ignored. Then if you go on, they say you're mad. Then if you go on after that, they lock you up, as they did with the suffragettes. Then there's a pause. Then you can't find anyone at the top who doesn't claim to have thought of it in the first place. And that is how we make a change. Now, the consensus point comes at the end, but doesn't usually begin a movement for political change, I don't think.
I think on referenda specifically, there are three cautionary tales. One is California, where people vote for contradictory things. They vote for no more taxes, and then they vote for spending programs. There's the Swiss cautionary tale, you vote every Sunday, and populists have their moment in the sun. And there's the Irish cautionary tale, where people vote for something other than they're actually been asked to vote on. And so I think one has to approach referenda with a great deal of caution, but I would not exclude them as long as the conditions are set up for a sufficient number of votes to call them and they can't be manipulated and so on. I wouldn't exclude them, but if it were to come to ratifying a constitution or constitutional change, I would look for two criteria. I think there should be a majority in favour in each part of the United Kingdom, and I think there should be minimum participation level by those who are eligible to vote. And I think the justification for this, apart from making sure that everybody is comfortable with the outcome, is that it's an incredibly important discipline on those who are drafting, because they have to be sure that whatever they're drafting is going to be salient to people. And if it's not going to be passed, and that's the end of the story. So salience is a really tough test.
One last question, just Tony Benn, if he will forgive me on this point, and I didn't quite understand it in your 1991 proposals on a Welsh Parliament, is whether you saw that as having full lawmaking powers and tax-raising ability, and how we square the English-Welsh relationship, where you have a country which has a sort of £20 billion tax-raising capability, but a £30 billion cost attached to it. And in the two sentences in your proposals, obviously didn't go into. I just wondered what your view was.
Well, I see the referendum as being the only way you can legitimise a change in the power relationships of the people. And that's why when you had a mayor of London changed it so London had to have a referendum, and that was true all the way through. And I think on the Lisbon Treaty we should have had a referendum, and I think the question of a referendum will come up again in the present circumstances. But the reason that you justify it is because anything that alters the rights of the people to make the laws they want is of such importance it has to be cleared with the people because they're sovereign. And that's the way I look at it. If you have a referendum on every bill, then it would be quite impossible. You'd have massive campaigning and I don't think sense would come out of it. But on the constitutional change, then I think a referendum is necessary.
I wanted to try and bring this European thing back and maybe bring Chris back as well on this debate. The reason being that it is possibly, you talked about the moment happening, the moment when the logjam breaks. Whatever preparatory work you've done, you've had discussions, you've had debates about codification, there comes that time. And it could happen, probably not over the next couple of weeks, maybe, who knows. But it could happen at some point in the future because of the European situation. So, in a sense, what I'm reaching towards is trying to get your views on, would a written or codified settlement be a protection for Parliament to have a serious role in debates about the European Union, and actually to be, if people didn't wish to go further into the European Union or didn't wish the terms to change, that Parliament, rather than the executive, would have a serious role in that process. Not an exclusive one, but a serious one, which arguably isn't the case at the moment. Would a codification help in that?
Haven't we seen the parallel process taking place with treaty ratification, for example? We haven't had a constitution, but we have had a law, and it seems to me that a constitution, because of the legitimacy model that I've mentioned, would make that protection stronger. So, A, you need the provision for involving Parliament. B, is that provision more effectively secured through an ordinary Act of Parliament or through a constitutional Act of Parliament? But that's as far as we can go. You can't have a written constitution that the one I proposed, which would abolish parliamentary sovereignty. I think it's just unrealistic at this stage. It's what I want eventually, but couldn't have it at this stage. So what Parliament would be doing is creating, as many countries have done, a Bill of Rights or a constitution, and one of those provisions would be the strengthening of Parliament's role generally within this constitutional framework, including its surveillance over the EU, for example. So yes, I think it would help.
I think it's the debate rather than the actual written constitution. If the issues we've been talking about are made central in the debate, then people will be deciding whether they do want to be governed by some external body or by the people they know and can remove and who listen to them. And I think that is the most important thing. Whether we can really look to a rounded constitution now, however the moment may come, is a bit an illusion. But I think out of that discussion will come some interesting public debate which will shape opinion and will safeguard our own interests as a nation and a responsible country in the world, but still somebody whose job it is, like every government, to protect its own people.
Can I just add, my view of parliamentary sovereignty is not that a Prime Minister says to Parliament, unless you do what I want, or what I've signed up to, or what I've agreed with President Bush, that the government will fall, or civilization as we know will collapse, or the markets will rip our economy apart. So vote, follow me and vote this way. I don't regard that as parliamentary sovereignty. Now, you could argue that is Parliament giving its endorsement, and on all three of those issues we've had examples of that over the last 10 years. But I don't regard that as Parliament setting out its view, having a sensible debate and working through the issues. And of course there has to be executive power, but really what I'm feeling towards is how do we define an effective role for our Parliament which gives it a genuine sovereignty, a genuine involvement. Even in a minor way, we've seen some of the Nordic parliaments actually debate issues before their prime ministers go off to summits, not after and receiving a report and having this blackmail of either you follow me or the world collapses. Isn't there a way we can devise that so that, in a sense, maybe putting off the moment when constitutional change happens?
Well, if Europe decided to force this country to have a general coalition and appoint the Prime Minister, as in Greece and Italy, then I think people would see that was such a big thing.
That could be a moment where we said Parliament has that decision, not Mrs. Merkel and Mr. Sarkozy.
That's right.
Frank, sorry, I
Well, just to go back to the Parliament and the referendum, I think it's worth remembering the deep aversion in Germany to having referenda. And of course it goes back to the 1930s, and referenda can be manipulated by executives. And so I think any constitution that provides for referenda, as I think it would have to do, would have to guard against manipulation by the executive. And therefore this opens a role for Parliament in deciding whether to call a referendum, on what terms, and possibly even what the question might be.
And would that also apply to the media? We're undergoing this experience at the moment of e-petitioning in the House of Commons, which I think owes more to the editorial meetings in the Daily Mail and the Sun than individual members coming up with bright ideas. Is there a role for how the media needs to play its significant and important part in the Constitution?
I think it's very difficult at the moment to define a role for the media because the whole media scene is changing. I mean, traditional media are basically disappearing down the tubes, and the new types of communication are being formed. And I think one of the problems with the new forms of communication is that it fractures opinion as much as it seems to bring it together. And I think if you look at, say, reasons why we have the True Finns in Finland or the Tea Party in the United States, part of it is due to a different style of communication between groups, which owes itself to the new media rather than old media. So there's a whole totally different set of issues there.
I mean, wouldn't it be right to say, I mean, the True Finns emerged as a powerful force because none of the existing political parties were reflecting the wishes of a significant proportion of the population, who then started and responded very positively to the message from the True Finns. And that's really what happened to that, isn't it? Nothing to do
Well,
with
that's certainly that's the trigger, but then the question is, how do such groups organise? And these days they tend to organise as Finland organises, through the mobile phone.
Eleanor?
Just on that, my alarm bells were ringing when Frank talked about the manipulation of referendums. This is something that I have personally gone on and on about for as long as I can remember. Would you say that it would be essential for a referendum to be taken seriously? Well, let me say even more so than that, would it be necessary for a referendum to have any serious effect, for the question in a referendum to be decided by a body such as the Electoral Commission, which is non-party political, and that there should be a cap on the amount of spending that a campaign in a referendum can make?
Well, on the latter point, I'm very anxious, if at all possible, to avoid campaigning on the proposals for a constitution. I mean, otherwise, I can't see how it's going to happen otherwise, unless it is presented as something for which there is cross-party support. I completely agree, however, with Frank's point that you do need many safeguards to avoid manipulation. And so I agree with you that the Electoral Commission could play a huge part. I also think that the safeguard of having Parliament dictate the format of questions is a very, very sensible one, and that should attract cross-party support. It just seems to me that ultimately you come back, I think, to the same questions. How do you persuade the executive, that's the practical question, that they should have a written constitution? Answer, by proposing relatively low-key reforms, but proposing those reforms which have cross-party support, being prepared to trade some principles if they are policy principles rather than constitutional principles. But above all, getting it in force, because once it's in force, it will acquire legitimacy, and people will start thinking much more constitutionally than they ever have in this country.
Colleagues, thank you. Witnesses too, Richard, Tony, Frank. That's been a very interesting exchange, and it's also one that has great relevance. I think as things are unfolding in Europe, some of those transformative powers migrating, that clearly is happening to some degree, often without legitimacy, or whether there are moments where it looks like there's more of a need for a constitutional change than at other times. Those moments may well be appearing on our radar very, very shortly. So, although this appears at first sight to be dry and long-term, there is a degree of topicality and urgency about our consideration and safeguarding and enhancing certainly the role of this place and the role of our democracy. Fascinating morning. And of course, gentlemen, if you wish to drop us any further notes on any other thoughts that you have on the train back home, we'd be very grateful to receive it. Thank you so much for your time this morning, and thank you for the committee members for a really instructive set of questions this morning. Thank you all.
Thank you very much.
Portcullis House, line 4, the Wilson Room.